This is a review of Module 13 on criminal justice. I'll begin with the review, of course. In a prior module, we discussed the concept of procedural due process. Procedural due process refers to the rules that government must follow, things government must do before it can deprive a citizen or any person of life, liberty, or property. There are some procedural due process rules provided in the original Constitution, and we covered those in a prior module: the right of habeas corpus, protection against bills of attainder and ex post facto laws, the right to a jury trial, rules for evidence in treason cases. Those are all part of the original Constitution. Other procedural due process rules are enumerated in various amendments to the Constitution, and that will be the subject of this module. These rights that are provided in the amendments are stated in very general terms, and they tend to address or prevent things that unfair practices that prior kings and parliaments of European history have been notorious for infringing upon. So not wanting that to be the case in this new nation, our founders included protections for them in the original Constitution and the Bill of Rights. And then as the history of our nation developed, our U.S. Supreme Court has interpreted those general terms of the amendments and elaborated on them and given them meaning. And even going beyond those rules and precedents, on the basis of those rules and precedents, state legislatures, lawyers, judges, bar associations have developed rules of court, procedures that are applied in criminal prosecutions. So these are rules that attorneys must learn and must apply in the context of criminal prosecutions that are based on Supreme Court decisions interpreting the constitutional protections of procedural due process. Most, but not all, of the criminal due process protections have been incorporated through the 14th Amendment's Due Process Clause and apply to states. If you would like to look specifically at a list of what's included and what's not, there's a hyperlink in that word incorporation that you can use to go and look at that list. There's just very few. Most of them have been incorporated. Like, for example, the grand jury requirement. That has not been incorporated. Okay. We start out by talking a bit about the way we enforce the criminal due process protection. So we're starting out with the exclusionary rule. This is a judicially created way to police the police, to enforce the protections of criminal procedure law. The rule is that illegally obtained evidence cannot be used to establish the guilt of the person it was illegally obtained from. So I'll say that again in case you're writing it down. The exclusionary rule provides that illegally obtained evidence cannot be used to establish the guilt of the person it was illegally obtained from. That is the rule. This protection extends a little bit further than the precise evidence that was obtained. It will include any additional evidence that would not have been discovered but for having discovered the illegally obtained evidence. So it's whatever is within this sort of causal link between the illegal behavior of the police and the evidence they obtained by that illegal behavior. So whatever is in that kind of causal chain is excluded from the jury's ears. They will not hear or see of it. And that is the trade-off. So evidence that it could be incriminating evidence, it could be supremely valuable, it could be a confession, it could be the smoking gun. But the rule would prohibit the jury from ever seeing or learning of it, which means sometimes factually guilty defendants are exonerated because of a mistake or illegal behavior of the police. That's how it works. It is a trade-off. Okay, so look for a minute at how we came to have this rule. It was first used and applied in the early 1900s. It was recognized by a Supreme Court decision as being essential to due process in 1914. But that was in a case involving a federal prosecution. So for a time period, there a practice sort of developed where if the FBI obtained evidence illegally and it could not use that evidence to prosecute a suspect, they could give the evidence to state prosecutors who were not guilty of violating any criminal due process rights and could use the evidence and prosecute the defendant for the same crime. That was known as the silver platter doctrine. And I'm not saying it was used all the time. It may have only been used once or twice, but it was out there. This was kind of a loophole in the use of the exclusionary rule. And it was available until the decision of Mapp versus Ohio in 1961. And this involved the arrest of a woman named Ulrey Mapp. She was, I believe, in a home. It was a place where she lived, but the police had not shown up looking for her. They were looking for someone else who lived there. They did not have a warrant, though, and they kind of forced their way in and conducted a search over her objections and didn't find the contraband they were looking for, didn't find the person they were looking for, but they found pornography. So they arrested her for possession of pornography and prosecuted her for it. And she challenged her conviction, appealed, and at the Supreme Court, the court held that the search was illegal, that it was warrantless. Therefore, any evidence that was obtained should be excluded, and that exclusionary rule was a necessary aspect of criminal due process, so fundamental and essential to providing due process protections that it would be incorporated under the 14th Amendment. And so now there goes that silver platter doctrine is gone. Now, even states cannot use evidence that has been illegally obtained. The exceptions that exist, there actually are several exceptions to the exclusionary rule that are discussed in your textbook. The good faith exception, when the police or prosecutors bear no culpability for violating a defendant's rights, when there's some sort of technical error made by a clerk in the preparation of a warrant, for example, if the police aren't guilty of doing anything wrong, then they can still use the evidence for prosecuting the defendant. Impeachment, that's part of the rule. Evidence, the exclusionary rule only prevents prosecution from using the illegally obtained evidence to establish guilt, but they can use it to impeach the testimony of a lying witness. And it only applies, here's another exception. It only applies to the person who had the privacy rights in the evidence. So there's a standing exception there. That's legal standing that applies. Evidence can be obtained. Evidence can be used against the defendant in spite of an illegal search if the police would have obtained the evidence anyway. That's the independent source or inevitable discovery exception. And then there's that causal connection that's part of this. What is excluded is only the evidence that the police would not have but for their illegal action. The Fourth Amendment. Now we talked about the exclusionary rule and how the Fourth Amendment is enforced. Let's look at what the Fourth Amendment actually provides. So first of all, what kind of searches does it apply to? It doesn't apply to every single type of search, only certain searches. So what kind does it apply to? It applies to searches of persons or property over which a person has a reasonable expectation of privacy. So this is a privacy right, a personal privacy right. It's not just a matter of location or physical intrusion. It applies to words, it applies to information, anything over which a person has a reasonable expectation of privacy. A search of that is protected by the Fourth Amendment. So the Katz decision is one that is highlighted in your textbook. And that was the case where police were not able to use tape recording of the defendant's phone conversations. The police were outside the phone booth. Their wiretap was outside the phone booth, but the defendant still had an expectation that he could not be heard, that his words were being kept private. So because of that, because it is a personal right to privacy, the Supreme Court prevented the police from using that tape recorded conversation. The more recent case, I think this one's in your book, it involved the case where police they were outside the home, but they had the technology to pick up the heat signature of items within the defendant's home. And that was considered a search for purposes of the Fourth Amendment. So it's not a matter of a physical intrusion. It can be just through the use of technology. If you have an expectation of privacy over the subject of the search, the Fourth Amendment applies. The two cases that are really new that I asked you to read, the Riley case and the Carpenter case. The Riley case provides that information stored on your cell phone is something you have an expectation of privacy over. And so Fourth Amendment applies. And then the Carpenter case, the most recent one, involves cell site location information, which is a little curious because cell site location information is stored by a third party. It is, in fact, turned over by a person to a third party. It is not maintained perfectly private by the defendant. It's turned over, but that sort of disclosure to your cellular service provider is considered too technical to count. So the court says, individuals still have a reasonable expectation of privacy even over this cell site location information that is technically shared with a cellular service provider's computer. So that's what searches it applies to. What about seizures? So you can have a seizure of property when property is collected by the police as part of an investigation. That's easy. What about a seizure of a person? So when does the Fourth Amendment apply to a seizure? Like when does it kick in? Because sometimes police could be like, if you're just walking on a city street, they could stop you and ask you a question. So you've been stopped by the police, but that's not a seizure. They're just asking you a quick question. That doesn't count. But it is when a person is stopped and can reasonably conclude that they actually are not free to leave, that they can't just walk away from the police. At that point, this is considered a detention, not a formal arrest, but a temporary detention, and the Fourth Amendment does apply to temporary detentions of an individual. So there's a seizure, obviously, when a formal arrest has been made, but also even before you get to an actual formal arrest, these temporary stops, those are also protected by the Fourth Amendment. So the Fourth Amendment has two clauses, a reasonableness clause and a warrant clause. And we'll talk about the reasonableness clause first. So the search and the seizure both have to be conducted in a reasonable manner and a reasonable scope. So the scope and the extent of the search must be reasonable in light of what the police knows. If the police officer only has some sort of suspicion of criminal activity, then the scope of the search is far more limited than when they have actual probable cause to believe that the individual has committed a crime or has contraband. So the greater the evidence is, the wider the scope and extent of the search or seizure can be. It's got to be connected and appropriate in light of the police officer's knowledge. And the manner of the search, like the manner of the seizure, when does, when can the police use force, for example? That's part of the reasonableness clause. that then comes the warrant clause. So there are certain requirements that warrants must meet. They must be based on probable cause. That's straightforward in the Fourth Amendment. They must be supported by oath or affirmation. Some witness or the police officer has to swear to tell the truth, the whole truth, and nothing but the truth, when they are providing the basis of probable cause. So you have to have probable cause that is supported by sworn testimony. And then that warrant has to be signed by an impartial judge. And the warrant has to be very specific. It has to describe the scope of the search with particularity. So that's the requirement of the warrant clause. Now, the Constitution does not state when warrants are required. It just says that when they are required, these are the aspects of it that must exist. It must be based on probable cause, supported by oath or affirmation, and describe the scope of the search with particularity. But it doesn't say when a warrant is required. Okay, so you've got sort of like the minimum threshold that the Constitution establishes. All these amendments give you the minimum threshold. Courts interpret the language of the amendments and kind of give more of the specific details to it. So it's court interpretation of the Constitution that tells us when warrants are required. And so they are required, generally speaking, for formal searches and arrests. But there are a lot of exceptions for when warrants are not required. And these are exceptions recognized only in court decisions. They include when a person consents to a search. Okay. If you consent to be searched, you're waiving your right to privacy. So there's no need for a warrant. Abandoned property, no expectation of privacy there. No warrant required. Open fields, same sort of thing. Fourth Amendment doesn't apply because that's something that's plainly visible. There's no expectation of privacy over it. No warrant is needed. In exigent circumstances, such as to avoid the destruction of evidence, a fleeing suspect, no warrant is required there. The police, they need probable cause, but they don't have to stop and go get a judge to sign a warrant before they arrest a fleeing suspect, excuse me. Special rules apply for traffic stops. You still need probable cause to stop a vehicle, and there are specific rules about the extent of the search of the vehicle. But you don't always have to stop and get a warrant before you can pull somebody over who you know is violating or has violated the law, or you have probable cause to pull them over. Administrative searches like in airport security, parole officers, probation searches, school locker searches. In those situations, the warrants are not required. So there are a lot of exceptions. Is where I'm going with that. All right, now we go to the Fifth Amendment. And this is kind of a list of rights that are covered in the due process or covered in the Fourth Amendment, the Fifth Amendment. Now, we've already talked about one part of the Fifth Amendment, and that's the General Due Process Clause and the Takings Clause. So we're not going to talk about that. We're going to talk about the other ones. First, the rule against self-incrimination. That's the testimonial privilege that is provided by the Fifth Amendment. All statements to police must be voluntary and credible, not the result of coercion. So a defendant has the right to remain silent, to not be forced to speak. They can plead the Fifth. They can refuse to talk to police. That is your right. They can't be compelled to testify at their own trial. Defendants have the right not to take the stand in their own defense. They can choose that. That right does not exist in civil court proceedings. So the Fifth Amendment doesn't apply in private lawsuits. They only apply in criminal prosecutions. But there are some situations that are very technical and we don't get into in this class where, well, what usually happens is this civil proceeding is put on hold. If there is a criminal prosecution based upon the same information, the same factual scenario, they just don't they don't go forward with the civil case until the criminal prosecution is done. That goes first. And so that kind of takes care of the self-incrimination rule. But generally speaking, the Fifth Amendment doesn't apply in civil proceedings. And it's testimonial. So it doesn't mean that you can refuse to give a breathalyzer test or refuse to give a blood test, like a DNA sample or a fingerprint or a hair sample. The Fifth Amendment does not apply to that. The testimonial rule doesn't apply to that. It only applies to words, to the right of an individual to just remain silent. The big case on this issue is the Miranda case that everybody knows the rules. Like, what does the police officer have to say when he places you under arrest? Well, those are the Miranda warnings. Okay. So when must they be given? My first question, why? So why do you have to give these warnings? And it seems kind of a little tedious because doesn't everybody know that they have the right to remain silent and the right to attorney? Well, no, they don't all already know. There could be the people who aren't really aware that they have the right to remain silent or the right to have an attorney present for questioning. And so it all kind of centers around the fact that a person, you have these rights, and you have the right to waive them. And so if you start talking, it suggests that you have waived this right, or these rights, plural. And so the way the court interprets the rule is it is the police and prosecution's burden to establish that the defendant did in fact waive this right to counsel and right to remain silent. And they can't meet that burden unless they are for sure the defendant knew what his rights were and knowingly, voluntarily waived them. And so giving these warnings assure that the defendant is aware of their rights and is knowingly and voluntarily waiving them. That's why they have to be given. And that was the explanation in the Miranda case. When must they be given? They must be given before a custodial interrogation. So custodial means that the defendant reasonably believes that he is no longer free to leave. He is technically in police custody. He cannot just walk away. Interrogation means activity, not just questioning, but any activity designed to elicit an incriminating response from the defendant. So put that together and you get a custodial interrogation. The suspect reasonably believes that he is no longer free to leave, and the police activity is designed to elicit incriminating responses. That is when the warning has to be given. It is the prosecution's burden to show that statements made by a defendant outside the presence of his or her attorney were given after the defendant received the warnings and waived them, that he knowingly and intelligently waived them. These statements are enforced, or this rule is enforced by the exclusionary rule. So any statements obtained in violation of this Miranda rule cannot be used to establish the defendant's guilt at trial, but can still be used to impeach him if he chooses to testify, or she could be female defendant. They aren't directly. Keep in mind that the Miranda rule, that is not required by the Fifth Amendment. So remember at the beginning of this lecture, I pointed out that the Constitution provides the minimum threshold. These are just general protections. The U.S. Supreme Court has interpreted them and given them more meaning and explained how they should be applied. And so you have elaborations on the general minimum threshold provided by the Constitution. And this Miranda warnings is just like the exclusionary rule. The Miranda warnings are the court's interpretation of the Constitution that kind of elaborates on what the Constitution builds up. And also, note this, states can provide greater protection for criminal defendants. So they can go beyond just what the U.S. Constitution provides. They can give greater protection than the Constitution requires. They just can't give lesser protection. Okay. The grand jury, now that's one of the criminal due process rights that has not been incorporated, only applies to federal prosecutions. The purpose of having, well, first of all, let's see. I hope you understand what a grand jury is. You probably do, but some students aren't aware that we are not talking about the group of people who decide the guilt or innocence of the defendant. This is a wholly different group of people, and they are called to hear only the prosecution's evidence, and no one's even been arrested yet. So they're just hearing what the prosecution knows about a defendant, and the grand jury is deciding whether the prosecution can arrest that defendant. Does the prosecution have probable cause to arrest this particular person? And if the grand jury, hearing only the prosecution's evidence, the defendant's not even there, hearing only the prosecution's evidence, is there probable cause to arrest? If so, the grand jury issues an indictment. And a grand jury indictment, the prosecutor arrests the defendant and the case moves forward. So that's what grand juries are. And they are private. They are not open to the public or press. They are kept very confidential. No spectators, no press. The purpose of them is to prevent prosecutorial misconduct or the abuse of power by prosecutors. So state prosecutions, state rules, state constitutions have their own ways of ensuring protection against abuse, prosecutorial abuse. Double jeopardy. So you know what double jeopardy is. That's in the Fifth Amendment. You cannot be prosecuted for the same offense more than once. That's double jeopardy. The catch is knowing when it attaches. So double jeopardy only attaches to a formal finding of guilt or innocence, or guilty but or not guilty, the formal finding, a verdict of guilt or not guilt over the same charge or crime by the same government jurisdiction. I'll say that one more time. Double jeopardy attaches after a formal finding of guilt or not guilty for the same charge, the same offense, by the same government jurisdiction, so by the court of, Greenwood County, or by the United States, whatever. So one government system, criminal system, that specific system cannot prosecute the same person for the same offense, but they could be prosecuted by another jurisdiction. So it only attaches to that one jurisdiction in which the formal finding of guilt has been, or innocence has been found. All right, the Sixth Amendment, right to counsel, is where we start. The Sixth Amendment guarantees the right to the assistance of counsel. And the original intent of the Sixth Amendment was that the national government, remember this is in the Bill of Rights, so we're starting out just limiting the power of the national government. It could not deny someone an attorney. So it did not require the government to provide attorney. It just meant that the government could not deny someone, prevent them from having an attorney. Okay, so that's the original purpose of the rule, only applied to the national government. States had their own constitutions, made their own provisions for the rights of the accused to have counsel. So at first we're just dealing with the national government. But there's kind of a long history of how that original intent and the original meaning of the Sixth Amendment has been expanded beyond what it specifically says. The modern rule then is what you expect, that the state must provide counsel, the assistance of counsel, to a defendant who cannot afford to pay one on their own. The landmark case involving the right to counsel is Powell versus Alabama. That's the Scottsboro Boys case. You've probably heard about it before, but just in case, this group of young men was riding on a train, coming, I think, from Georgia into, no. I think it was Mississippi into Alabama. Anyway, it's in the South. You get it. So the train comes to a stop in Alabama, and the young men are accused of raping two white women while on the train, which they absolutely did not do. And the women who said they had been raped were lying and later said and admitted they had lied. But what happened to the young men, you were supposed to read about that. That was part of your reading assignment, in the case. It was quite, a horrendous spectacle. But the state of Alabama had a law that said, that defendants have the right to the assistance of counsel, that could not be, the state could not interfere with it. And so there's, discussion in what you read about the effort that the judge made to kind of get some of the local attorneys to come in and represent the defendants, but they were rushing through the prosecution. I mean, they were arrested, put in jail, and the trial is like a few days later. And this is before the days of the internet. I'm not even sure there was a telephone available, maybe, but they didn't have time to call home and get help, get an attorney to drive to where they were in Alabama. It was rushed. The process was so rushed. And so they really never had a real opportunity to get their own attorney. And the judge's efforts to try to get local attorneys to come in and represent them was really rushed and imprecise and insincere. And they really never had the counsel they were entitled to get. They were convicted. They all went to jail. They all spent many, many years in jail, wrongfully convicted. But the U.S. Supreme Court did find that the right to counsel, is a matter of due process, and it's more than just not interfering with the defendant's effort to obtain their own counsel, but it is an affirmative obligation of the government to see that they receive the assistance of counsel. So that was, here's the language from the case. It makes it pretty clear. In a capital case where the defendant is unable to employ counsel and is incapable adequately of making his own defense because of ignorance, feeble-mindedness, illiteracy, or the like, it is the duty of the court, whether requested or not, to assign counsel for him as a necessary requisite of due process of law. And that duty is not discharged by an assignment at such a time or under such circumstances as to preclude the giving of effective aid in the preparation and trial of the case. That's what Powell says. The next big decision is the Gideon versus Wainwright decision. And it was in the Gideon case that the Supreme Court held that right to the assistance of counsel is it extends beyond just capital cases, extends into any felony prosecution. And then the Argersinger case provides what we currently have. It's not even just a felony. We hold that no person may be imprisoned for any offense, whether classified as petty, misdemeanor, or felony, unless he was represented by counsel at his trial. So it isn't just a capital case. It isn't just a felony. It includes even misdemeanors. So anytime a defendant is being charged with a crime for which he could receive 6 months in jail or more, he is entitled to the effective assistance of counsel. And so that's our next topic, is how that right to effective aid is provided. So defendants on appeal can claim that they did not have effective assistance of counsel, or their counsel was incompetent in some way. And the court then will, conduct a review of the record of the case and look at what type of assistance the attorney provided to the defendant. And so it's got to make these two findings. Number one, the defendant has to show that the attorney's performance was deficient. as determined by an objective review of prevailing professional standards of conduct. And number two, that the attorney's failure to provide effective assistance actually prejudiced the defense. Right? Those things are in your textbook. Courts recognize attorneys make judgment calls. That's just the nature of the job. So an attorney is not necessarily ineffective if he just makes a bad judgment call. I mean, people make mistakes. They're not looking at necessarily the outcome of a strategic decision. They're looking at the way the attorney made the decision, on what did he or she rely in making the decision. So it's looking at the process, not just the outcome. The right to have counsel arises at any critical stage in the prosecution. I wanted to mention that. So it includes custodial interrogations, lineups, pretrial proceedings, sentencing hearings, trials, and appeals. So pretty much covers the gamut. But that's when the right to counsel arises. All right, another right of the Sixth Amendment, speedy trial. The way that right is protected is through two ways. Statutes of limitation and rules of criminal procedure. Statutes of limitation refers to the amount of time that may pass from the event of the crime to the date on which the defendant is charged for committing it. These time limits will vary by crime, and they are provided by statutory law within each state. Some crimes have no statute of limitations, but once that limitation passes, no defendant may be charged for the crime, although there are very few. There are some exceptions that ensure fairness to the victims. After being charged, prosecutors and courts must abide by rules of criminal procedure that also include time limits for the various stages of the prosecution. These rules are in those books, the federal rules of criminal procedure and the South Carolina rules of court. Those rule books give the details and the deadlines, and they just ensure that the prosecution moves along at a steady pace, right? But the Supreme Court has never defined specifically the amount of time that can elapse between the crime and the prosecution, or the amount of time a prosecutor has to complete the case, to get all the way through trial. There's no specific time period. It's all just a matter of the circumstances. But there are statutes of limitation that give sort of these firm frameworks. And then there are rules of procedure that also include some time limitations, but they just ensure that there is no unnecessary delays. The public nature of a trial is something we talked about in other modules. It is a due process right held by an individual defendant for the trial to be public. But it's also just the aspect of our criminal justice system that it be transparent, that the public has the ability to go and see what is happening, to know how the government is working to provide protection for citizens, to provide community safety. So it is kind of a twofold. It is a right of a criminal defendant to have a public trial, but it is also just an aspect of judicial integrity and fairness and transparency. All right, now we're going to look specifically at trials, okay? You have a right to a trial by jury. That is a right that was inherited from the English common law. It is in the original Constitution, and the Sixth Amendment elaborates on that a little bit more. And note, the Seventh Amendment also provides a right to a jury for civil cases, but we're just dealing with criminal prosecutions. Trial juries most often consist of 12 jurors, but the Constitution does not require that. That's kind of just a feature of tradition. There's really no basis for it in the Constitution or even in court decisions. It's kind of just what we have. And some states don't have 12 jurors. It's not universal. The Constitution does not require unanimous verdicts. Some states don't have that practice. Most do, but it's not required. What is required is impartiality of the jury. That is in the Sixth Amendment. So we look at what do we mean by impartiality? Well, first you start with how citizens are called to serve on a jury. The jury pools, like what group of people are jurors drawn from? That's called the jury pool. And the way that's protected in our law, our legal system, is that they're selected from like randomly from public records. So there's no specific segment of the population jurors are drawn from that would discriminate on the basis of race or socioeconomic status or gender or ethnicity. There's no discrimination. It is general. It's just a very general basis, like driving records or voter registrations. Those are the kind of the big group out of which jurors are drawn. And in the end, the jury pools are sometimes absolutely enormous. I was called for jury service about a year ago, and it was, later learned it was for a very kind of, what's the word? It was a murder trial involving a lot of publicity. It was a big deal. I can't remember which one it was. But the group of people that were called this was before the jury was selected. The jury pool consisted of I think it was over 400 people. I was in the enormous courtroom with over 400 people who were being screened to see if they were impartial. It was interesting. So jury pools are really, really big. And you're randomly selected for service. But once you're called in, you go through a process called voir dire. It's that questioning process. So the group of potential jurors are there in the courtroom, and the judge and attorneys for both prosecution and the defense ask them questions to try to determine whether they are impartial. Based upon the answers, the jurors are, it's called strike. The attorneys are striking a jury. That's the legal jargon. So they're picking who will be among the 12 or however number of people will be on the trial jury. So based on their questions, attorneys can strike an unlimited number of jurors for cause. So based on the answer given, if it suggests that you were not impartial, you can be struck for cause, and there's no limit on the number of people you can strike for cause. Attorneys can also make what's known as a peremptory strike, and peremptory strikes are limited in number because the attorneys don't have to say why they are striking the juror. They just say, this is my, one of 4 peremptory strikes that I'm going to make, Your Honor. I'm striking this person from the pool, and you don't have to say why. That's called a peremptory strike. No cause, you don't have to state cause for it. However, you cannot use a peremptory strike in a racially discriminatory fashion, and that's the holding of the Batson versus Kentucky case I asked you guys to look at. When an attorney uses the voir dire process in a discriminatory fashion, the defendant may assert a Batson challenge. In that case, the Supreme Court held that the prosecution had violated the 6th and 14th Amendment because he had used his peremptory strikes to eliminate all African Americans from serving on the jury in a Burley trial against an African American defendant. Okay, so it smacked of racism. So that conviction was overturned because of the way the attorney had used voir dire to eliminate all African American jurors. So if you make a Batson challenge, the person asserting it, has to show that the prosecution was using the voir dire process in a racially discriminatory fashion. And then the prosecution has to provide race neutral reasons why they made the peremptory strike. So now you got to give cause. You got to state why you made that strike. So I use the context of a criminal prosecution. Batson challenges can be made in civil cases as well. Pretrial publicity is another aspect of impartiality of the jury. You're asked to read an excerpt from the Skilling versus U.S. decision. And this was involving a massive securities fraud scheme in the year 2000 that had received a lot of publicity. It was all over the news. And the court explained in that case, impartiality, it doesn't mean that jurors are wholly unaware of the case. So it doesn't require absolute ignorance of the case. The court is going to just consider the circumstances of the specific case, like the size of the community. Is it a little tiny town where everybody's reading the newspaper, and the newspaper has essentially indicted the defendant before he had a trial and convicted the defendant before he's even had a trial? So the nature of the publicity, and then the amount of time that has passed between the publicity and jury selection. All of that is kind of wrapped up in the specific circumstances of each case, and a lot of deference is given to judges to determine whether the publicity has been so bad that the defendant should be able to move the case to another location. Another right protected in the Sixth Amendment is the right to be informed of the charges against them. And that occurs repeatedly throughout criminal proceedings, all the way from the arraignment to other pretrial appearances. You know, you get the indictment form, the charge sheet. There are a variety of ways where the rules of criminal procedure provide the information about the nature of the charges against the defendant. Defendants have the right to call their own witnesses. So they have the right to subpoena witnesses to testify on their own behalf. And they have the right to cross-examine the prosecution's witnesses. Both of those are specifically enumerated in the Sixth Amendment. Both of those rights are. All right, last is the Eighth Amendment. The Eighth Amendment ensures proportionality in the punishment and the crime, between the punishment and the crime, proportionality. So there's the saying, the punishment must fit the crime. That's where you get that from the Eighth Amendment. Proportionality. It applies to bail. So if someone is arrested and the judge will determine whether the defendant can post bail and go and be released and leave the jail, and the amount of money that the bail is set at is meant to ensure that the defendant's going to show up. Because if he doesn't show up for his trial, he forfeits the money he's just paid in as bail. The amount of bail must be proportional to the crime. And also there's an examination of the likelihood that he may flee the jurisdiction. Cruel and unusual punishment is the other part of proportionality. To determine what is cruel and unusual, you have to compare the crime with the punishment. And so now we're dealing with when you're talking about proportionality and punishment fitting the crime, you look at the nature of the crime and the extent of the punishment. And where we get to the ultimate form of punishment, the death penalty, that is where the determination of what is cruel and unusual has evolved. It has changed over time. To even have the death penalty at all, for a period of time, that was in question. It was called into question by this particular case, Furman versus Georgia. A very narrow majority held in the Furman case that as to those specific defendants, the death penalty was cruel and unusual. There was a good bit of discussion. Several concurring opinions were written, calling out the existence of the death penalty at all, saying that any death penalty is wrong and that death penalty should never be used. But there was no majority on that. So the actual majority was very narrow, very specific to the particular defendants in front of it. However, the basis for reversing the sentence was because of the way the state had conducted itself with respect to those defendants. And so this is an area of examination, the extent to which states are ensuring fairness and proportionality, taking into consideration the nature of the crime, the defendant's past, those types of that type of information has to be taken into consideration. And many states at this time had not done that. And so when the Furman decision was made public, it was published by the court, states began, and it was a voluntary, but every state in the U.S. called for a moratorium on the death penalty. So for about 4 years, there was a national moratorium. It was not required by the U.S. Supreme Court. It's just what states chose to do. But in 1976, we had a new death penalty case come before the court, and there it upheld the death sentence to the defendant. And the reasons were, again, this is specific to the case, but the reasons were that the Georgia had then rewritten its sentencing statutes, provided for a bifurcated trial. So there would be a proceeding before a jury to determine the guilt or innocence of the defendant. And then there would be a separate proceeding after a guilty verdict has been imposed, where the jury decides what sentence the defendant should receive, and different additional evidence regarding the nature of the offense, the background of the defendant, whether he's a repeat offender, why he did what he did. All of that can be taken into consideration in that sentencing stage. And Georgia had started providing the right of an automatic appeal. So that was another reason. So after the Gregg decision there in 76, states resumed the imposition of the death penalty. They just had to change their sentencing procedures and standards. We've got a few other cases to look at where the particular sentence was determined to be cruel and unusual. The death penalty, this is in the Coker case, the holding, the death penalty cannot be imposed for rape of an adult woman. In the Kennedy case, the death penalty cannot be imposed for the rape of even a child. The Atkins case, the death penalty cannot be imposed on a defendant who is mentally retarded. The Roper case, the death penalty cannot be imposed upon a defendant who was a juvenile under the age of 18 at the time of the offense. So in those 3 cases, the court is saying, in this instance, the death penalty would be cruel and unusual punishment. It's not saying for all cases the death penalty is cruel and unusual. It's not saying any particular method of the death penalty is cruel and unusual. None of that's been decided by the Supreme Court. The very few decisions where the court gave this definitive rule, bright line rule, are the ones I just gave you about when it cannot be imposed, including like the Roper case. But all of this is happening through what the court terms evolving standards of decency. What was considered cruel and unusual when the Eighth Amendment was ratified in 1792, I think, it's very different than what we would consider cruel and unusual today. So this is, they call it the evolving standards. It can change. What we consider cruel and unusual, that it's determined based on our modern understanding of what is cruel and unusual, and not the understanding of people's 250 years ago. All right, just very briefly, we are reminded at the end of this chapter about the different criminal procedural rules applied to juveniles. You could spend a whole entire class on the juvenile justice system. They do receive due process protections. That was determined in the decision of N. Ray Galt, but their protections are not the same as adults. So N. Ray Galt listed what criminal due process protections children will receive. But if you want to go, you can Google it to look at the list of things that are provided to children or not provided to children. Children don't have a right to bail, for example. They can be held in court. They don't have a right to, the trials are private. They're not made public. So there would not be a public jury trial and criminal proceedings against a juvenile. But you can read about the way the juvenile justice system evolved very differently from the adult system, and the different ways that various states have gone about ensuring, um, logic and reason, and not being arbitrary in the prosecution of juveniles, providing them with some due process protections, but at the same time, relaxing some of the formal nature of the proceedings because we are dealing with a juvenile, a young person. That is the end of the review for Module 13.